case briefs, and so much more. LSData's got what you're looking for.
In a landmark 2006 case involving the arcane rules of easements, the Wisconsin Supreme Court found itself weighing the principles of property rights against the broader public interest. At the heart of the matter were two plots of land, the dominant and servient estates, owned by the Kostermans and AKG Real Estate, LLC. Historically, the Kostermans' land had relied on access to a public road via 3 overlapping easements across an adjacent 80-acre property. These easements, established in 1960 and 1961, had been granted when both properties were owned by the Chvilicheks. However, once ownership changed, friction brewed over whether these easements should continue to exist if alternative public road access was provided. The Court of Appeals made their decision in a mixed verdict, affirming the termination of the 1998 easement while upholding the 1961 one. However, AKG Real Estate appealed the decision, throwing the case into the lap of the state's Supreme Court. The justices were tasked not only with interpreting the language of the unambiguous easement documents, but also with deciding how the doctrine of changed conditions applied in this context. In a decision written by Justice David T. Prosser, the court upheld the rights of property owners, ruling that a servient estate, the grantor, in this case AKG Real Estate, could not unilaterally terminate an express easement. In essence, it asserted that the owner of the Kostermans' property would continue to have the right of passage even if AKG provided an alternative road. The court also highlighted the potential chaos if the general rule was deviated from, reasoning it would lead to property rights, uncertainty, spur litigation, and unfairly advantage servient estate purchasers. In this tug-of-war between property rights and convenience, the Wisconsin Supreme Court charted a course favoring traditional property rights. The decision served as a legal reminder that the words in a deed matter and that alterations in property access should not be unilateral, even in an era of modernization and change.
Case briefs and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.